Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Razan Pereira. The Congress on Sunday accused the government of attempting to carry out 360-degree profiling of citizens and claimed that the DNA profiling bill was violative of the privacy and autonomy of people. Accusing the government of repeatedly displaying intrusive and nosy behaviour, the Congress spokesperson Abhishek Singhvi said that the BJP-led government wants an India that is defined by them. The DNA profiling bill, based on the one prepared by the Law Commission, recently states that national and regional DNA data banks will be set up for maintaining a national database for identification of victims, accused, suspects under trials, missing persons and unidentified human remains. The bill was introduced to the Lok Sabha by the Minister of Science and Technology, Vardhan, on August 9, 2018. On this edition of The Big Picture, we will analyze the DNA Technology Use and Application Regulation Bill of 2018. Joining me on the program today are P.K. Malhotra, former Secretary, Ministry of Law and Justice, Government of India. Also joining us on the program, Piyush Singh, Advocate of the Supreme Court, and Chakshu Roy, Head of Outreach, PRS Legislative Research. Thank you to all my guests for joining me on this edition of The Big Picture. Chakshu, let me start the program with you. What are the salient features of the DNA Technology Use and Application Regulation Bill of 2018?
Frank, I think if I had to broadly break down the bill, I would break it down into two or three parts. The first part is the reasons for which DNA would be collected. So the bill specifies that there's a schedule, and there are issues listed under the schedule under which there are a majority of criminal offences, and there are some civil claims, so to say, for which DNA would be collected. Then there's another part of the bill which really talks about the fact as to how what are the other circumstances in which the DNA would be collected. So it says from a crime scene, from people who are either witnesses or people associated around the crime scene, DNA would be collected from there. Then there is a provision around safeguarding the DNA information and provisions around privacy. And then there is a section of the bill which talks about a regulatory mechanism and how this data bank of all the DNA which has been collected, how will it be regulated, and there's an authority that is established. And finally, there are penal provisions which are provided that in case there's a transgression of the DNA database in terms of privacy or unauthorized use, then what are the penalties involved? I just wanted to step back and also say that that this is a bill which has gone through some level of debate before Parliament. So, the statement of objects and reasons, which you also refer to, talks about the fact that there was a 2003 committee. That committee recommended a bill. That bill then went to an expert committee. That expert committee came out with the bill, and then a draft of the bill was referred to the Law Commission, and the Law Commission recommended a draft. And the current bill, which has been introduced in Parliament, mirrors some bit of the bill that was recommended by the Law Commission.
Right. Mr. Malhotra, what is the history of the bill, and what shape has it taken over the years?
As my panelist colleague has already said, it's not that all of a sudden it has cropped up and the kind of criticism which is coming. To my mind, it doesn't seem to be valid because it is a well thought of bill which has been introduced. You see, DNA technology is based on sound scientific principle, and it's not that the bill has been brought in a day or so. As has been rightly said, I think initially it was in 2003 that a DNA profiling committee was constituted, which has gone into the detail of all this profiling, why it should be done, in what cases it should be done. And then that report of that committee has been examined by another expert committee which was constituted in 2012. And based on that, a bill was drafted which was again considered by the Law Commission of India. And the Law Commission of India has also gone into all these aspects, more particularly the concern which have been expressed with regard to the protection of information which will be collected under this. Even for collection also, and even for DNA profiling also, the kind of laboratories and other agencies which will be authorized, how their accreditation will be done. On that also, the law makes a provision. Now, the law itself constitutes a board which is a very high profile board on which there will be a chairman who will be secretary of the Ministry of Science and Technology, and then there will be a vice chairman of the committee who will be a man with having 25-year experience in this particular area. Then there are members who will be heads of the investigating agencies or their representative, like INA's representative, like Director CBI's representative, Ministry of Law representative, and other experts will be there. There are about 13 members who will be constituting this advisory board. And the advisory board has been given wide power with regard to as to how the accreditation of these agencies will be done, and how this national DNA data bank will be constituted, and how DNA state data banks will be constituted, and how the information will be transacted or transferred between them.
Since we're talking about the boards, Mr. Malhotra, there's a lot of criticism as far as, newspaper articles are concerned, who believe that too much power is being given to the board.
Well, till the time the power is regulated by the Act of the Parliament and the rules are framed which are strictly implemented, and the protection is provided by the Act itself, that if somebody is misusing that or violating the rules, then there will be strict punishment. I think that is a sufficient safeguard. Probably the kind of similarity which is being drawn is with regard to the data which was collected under Aadhaar. Please appreciate, when data was collected under Aadhaar, at that time there was no law. Aadhaar came much later, and protection have been built in that. Of course, that is a separate issue. But this is a law which is being enacted today, and under this law itself, protection is being provided, and in case somebody is misusing, how that misuse will be dealt with, punishment is prescribed. It is an imprisonment for 3 years or a penalty or a fine of 1 lakh rupee. Laboratories, when they are collecting the data, how they will be using this data, and when it is to be destroyed, there will be rules made to that effect. And data bank, how the data bank will be storing the data. For that also, even in the principal legislation itself, safeguards have been built, which will be then further supplemented by the rules to be made on the basis of the recommendations made by the advisory committee.
Right. All right. So Mr. Malhotra is suggesting that the bill itself has done the rounds. A lot of people, a lot of expert panels have looked at it, and it's a well-drafted bill at the end of the day, is what Mr. Malhotra is suggesting. Let me go across now to Yatish Rajawat, Editor-in-Chief of the DNA, joins us on the program right now. Yatish, welcome. Thank you for joining us on the program. As far as this bill is concerned, what are the biggest challenges really?
Well, I don't see any challenge per se in the bill, Frank. The bill is, as Mr. Malhotra pointed out earlier, is well drafted. Now, there could be issues, and it has been made to be a political issue, which is unfair, because ultimately what this bill does is creates another data point to identify individuals, citizens, and people. Now, the storage of the data and saying that it basically violates the privacy of an individual is a misconception of sorts. And this is, I think, this is another one of those things that the opposition is kind of putting forward just for the sake of putting it forward. They should realize that, opposing it on the grounds of privacy does not really make sense, because we actually, Indians do not care too much about our privacy. We give our mobile numbers and our email IDs and even our blood group so easily to anybody who promises a small incentive or an award at a cafe, that concerns around the privacy of DNA are totally misplaced. So fundamentally, Frank, I don't see a challenge in the bill.
Right.
Here.
Right. Let me take the points that you're making to our advocate on the panel today and find out from him. Does the bill come in the way of an individual's right to privacy, really, Piyush?
Not really, Frank. It may be challenged in Article 23, self-incrimination, but for that also Supreme Court, though, have given a judgment on right to privacy as well, which is a constitutional bench judgment, 9-bench judgment. On 23 also, for self-incrimination also, Supreme Court time and again have said that self-incrimination is a right, but it cannot be an absolute right. So there are devices or there are mechanisms. DNA tests have been allowed in, I would say, previously, and it can be allowed again. The more important issue, Frank, here is what are the problems which this bill addressed to look into? I would say it is much more into looking into effective judicial implementation or effective judicial mechanism to improve that mechanism. Now, when we are talking about it, we need to go into much more details, or I would say the grievances or the problem the country is facing. So, for example, the data collected in such cases, the indexes which have been divided are, one is crime scene index, one is a missing children index, one is a deceased index, one is an under trial index. Let me give you an example for each one of these. So, for example, a missing children index. There's a data which there are reports 175 children in India go missing every day. 175. And the impact of it, which we can see across the country, with the unfortunate incidents of lynching. Second, there are dead bodies not being recognized. Every year there are more than 4,000 FIRs where the dead body of the victim under section 302, a murder case being happening, where the victim is not being able to identify who is the person dead. We cannot identify because the face and the bodily features cannot be recognized, and who has killed him can't be recognized. That FIR does not name the victim, the FIR does not name the accused. Nothing is there, the charge sheet is prolonged. So this is for the deceased. Now let me tell for the under trials. Very recently there was a judgment of the Supreme Court, it was a couple of days back. There was a rape convict who has spent 7 years into imprisonment. Supreme Court, after he spending 7 years, says that there was no evidence against him. Now that is offenders index. So Frank, this is the kind of challenges the country is facing presently. Now, for that matter, under trials index. Now all those cases wherein the DNA test could assist them, and I would say those are the people who can primarily be benefited out of it. If they or their family, or I would say the accused or the victim or whoever is a part of the system, it's for their benefit, this DNA test and this profiling has to be done. And now when we're talking about their right to privacy, we have to balance each right. Now when I'm talking about under trials right of a children, missing children or his family or his parents, we're talking about the right to life. So here we are talking about the right to privacy. Oh, let's not share a detail of a missing child or the DNA of the parents of the missing children, because that's how it is supposed to be done. So for example, if a child is missing, you cannot get the DNA of the child. So first, the parents are going to go to the authorities and voluntarily give their DNAs. And then if a child is located, any of those child is located and those DNA matches, so that can help the authorities in getting the child back to the parents. This can be one of the wonderful ways of doing it. So if you look at it the other way around, you're trying to balance up, you're trying to compare apple with oranges. So I don't think so it will be a violation of right to privacy until and unless somebody tries or a government tries at which can be as a propaganda against the arm twisting exercise. So any offense above 7 years, I would say, can be a corruption charge against a rival opposition leader. So in that case, yes, you have his DNA profiling. For other offenses he would have committed under XYZ things, his paternity and all those civil matters, yes, it can be misused. Yes, in those cases it can be. But for otherwise, for 5 indexes, they are majorly discussed, which are not the exhaustive list, but those 5 indexes, it's a beautiful piece of legislation.
All right. Established then, as far as all the speakers are concerned, that it is something that is in the right direction and something that is the need of the hour at this point in time. Taking the discussion forward, capacity building, Chakshu Roy, is going to be a major challenge as far as this particular bill is concerned. Does the bill say anything about collection and storage of DNA data?
Frank, the bill makes adequate, let me rephrase that. First, the bill makes provisions for building capacity, for the officers who will be involved. And it also specifies in the way in which the data will be collected. And I think it will be useful to tell the viewers as to for what category of persons will the data be collected. And Piyush referred to this. So there is a category of people, from whom consent will be needed before you can collect the data. So if you are, if you've committed an offense, where the punishment is less than 7 years, then the authorities need to take your consent before your DNA is collected. And if it is an offense for which the punishment is more than 7 years, then obviously it can be taken automatically.
One automatic question that comes in at this juncture is, can you deny that permission?
I think, so we'll have to see as to how the regulation gets framed. But I'm assuming if the phraseology is asking for consent, then you can deny consent, right? Because otherwise I don't think it will be, consent to be taken. I mean, the very nature of the word would suggest that consent could be denied. The other part of it would be the fact as to, when the DNA is being collected, you're saying, it is being stored, and it is being stored at the state level, it's being stored at the central level. What are the kind of people who will have access to it, right? And that's something that the regulatory board will determine. For me, one of the things to think about in this piece of legislation would be, what is the ambit of the collection mechanism? And that ambit, there is some kind of there is a schedule which limits the ambit, and there is, the principal legislation which itself talks about the kind of, people it will be collected from. So it's not as if it's a wide-scale data collection exercise. So that's one. The second thing to be debated is the protection which is already put into the bill, is it adequate enough, or that needs to be supplemented? So that's a question that, which is open to the panel for debate. And the third thing is, when this, so this is a piece of legislation which, Mr. Malhotra very rightly pointed out, is based on scientific principles. DNA is based on scientific principles. And a number of times what happens is that the science advances more quickly than the law can catch up with. Now, in those circumstances, how do you ensure that the law can keep up, or the mechanisms of the law either are wide enough to keep up with the interpretation?
I think that's a very, very important point that you raised, Mr. Malhotra.
I think that is the reason you have created a specialized body, the authority, which has been empowered to make regulations, more particularly to provide for all such things which my learned panelist has been pointing out. Now, coming to the issue of privacy which you have raised, I think no doubt about it that privacy is a fundamental right now as per the even judgment given by the Supreme Court. But the concept of privacy, when you were talking of privacy in 50s, when you were talking of privacy in 60s, and the kind of privacy you are talking in today's world of technology in 2018, I think it has a different connotation at all.
It does.
And so far as the use of the information for this DNA profiling is concerned, I think the legislature is very clear, the government is very clear that where it can be used. You have said that whether it can be denied. Now, the law itself authorizes where you can use it. The list of matters where DNA testing will be permissible. There is a separate schedule attached to the bill, and I have a copy of the bill with me, and it has listed 4 different categories, and it is only when any of these case fall in any of these categories, only then the permission to use the data can be given. And if any of the authorities which has been created under the law, or an authorities which is in possession of the data, if it misuses, then there are penal provisions. So sufficient safeguards have been inbuilt. More particularly, if you look at the list which has been given, it talks about all the offences under the IPC. It talks about offences under special legislation like Immoral Traffic Prevention Act, or maybe medical termination of termination of pregnancy act, or maybe under motor vehicle, and there are certain legislation provided. Then the third category, as has been rightly provided, civil disputes and other civil matters with regard to the parental dispute, which is, I think, generally arises, and there are certain other cases like relating to medical negligence or unidentified human remains, etc. So suppose there is a ship is burns, or some other, if there is a road accident, bus is burned, and you can't identify the body. How you can do it? You can do it through DNA test only.
Yes.
So I think the kind of protection which the Act gives is a sufficient safeguard to ensure that the right of privacy, at least so far as this particular legislation is concerned, if the regulations are properly framed, and more importantly, if the provisions are properly implemented. I think implementation of the law will be more important than the legislation itself. If it is properly implemented, I don't see any reason how can there be more cases of right to privacy. I think that privacy issue will become subsidiary or secondary.
All right. Yatish Rajawat, I'm going to go back to the issue of capacity building. Do we have the wherewithal and the an adequate capacity building to deal with the DNA that will eventually be collected?
So, Frank, the technology is not so difficult in terms of collecting DNA and analyzing it. As you know, there are already a lot of Indian companies that have been collecting DNA and forecasting or projecting the kind of diseases that are buried in your genome, so to say. For these companies have been pretty successful. They've raised funding. So what they do is they collect your genetic material, and they, based on your DNA profiling, they say that how susceptible are you to, say, a debilitating disease like Parkinson, Alzheimer, which are all genetic in nature, or even cancers. Now, so and the equipment needed to do such kind of forecasting based on your genome material is not super expensive. It is expensive, but it is something that a normal lab can afford and build. So what will happen is that these capacities will not only get created in the government hospital or under the labs that the bill envisages, but it will also get created in the private sector labs. And as you know, the private sector labs have much bigger infrastructure currently for testing anything. Even some of the forensic tests, for instance, the government investigation bodies fall back on private labs because they have the equipment. So capacity building will happen as the demand rises, and it will rise up to fulfill that demand.
All right.
I would just like to add another point here, Frank.
Go ahead, please.
This bill has been in the pipeline for a very long time, and in 2012, if you remember, there was an expert committee specially formed under the Secretary of the Department of Biotechnology to address the issue of privacy. And subsequently, under the bill, there are several sections wherein it says very clearly that this committee will remain alive, and it will advise the central government and the state government in case new developments of which affect privacy of citizens come into bearing after the passage of the bill.
Right.
So I feel that when the legislation is being flexible in terms of accepting the changes in technology and the future impact of privacy, not even the current, the whole issue of politicizing the bill on the basis of its lack of concerns on privacy is completely a can of baloney, so to say.
Okay. All right. Another criticism or another, red flag that has been raised is the fact that the bill violates the principles of data protection. Now, is that really a fact? And who's going to be the custodian of the DNA data banks, Piyush?
See, again, the question goes back to the data protection, as again the allegations were that Sri Krishna committee's report was already there, the data protection bill was supposed to be, or that bill was supposed to be there as being passed as an act. So the first data protection act should be in place, and then this bill, if at all it has to come, should be in place. So in such scenarios, again, I would say the data protection bill, irrespective which bill comes first, I would say it already encapsulates the protection of any data. When it is, we're talking about any statutory data or constitutionally collected data, it's talking about protection of any data. So I would not say which act comes first, who is going to do that. With respect to the protection of the data, who's going to be the custodian of this data, the authority constituted, the board constituted under this act will be the custodian of the data as per the provisions of the bill. So I don't think so that per se collection of the data or protection of the data is going to be a problem. But even if it is, if that is a part of the criticism, I would say for any legislation, when a constitution was drafted for that matter, we had a lot of references from all future, I would say, constitutions throughout the world, from Ireland to United States, from UK. So when we are bringing in this particular act, there has been beautiful discussions. I would say the Law Commission has recommended to certain countries like United States and other European countries that how they have brought in a particular bill with respect to DNA testing and DNA profiling. And all those things have been discussed, and all those developed countries have been doing it for long.
Right.
So what stops India from doing it?
Okay, I'm going to take that point forward now to Mr. Malhotra. Quick closing comments from all my guests now. The point that Piyush was making, Mr. Malhotra, what has the experience of other countries been as far as dealing with DNA is concerned? And is there something that we can implement here in India, taking from there?
No, surely. I think the bill has been introduced, and if we follow the normal practice, it will go to a parliamentary standing committee also. which will be examining, when there will be opportunity, when all these issues which are being raised here or concern is being expressed, they will be debated, and I am very sure that the parliamentary committee will look into the practices which are prevalent in the other countries also. But so far as the protection of data is concerned, again I think, as my panelists have very rightly pointed out, protection of information, there is a specific provision made in the Act itself. So I don't see any difficulty when we are talking of the Sri Krishna committee report that talks about the general data protection law. But so far as this particular data protection is concerned, because the authorities are being created, authorities will be making a regulation, and any data which is being collected here, its misuse has been prohibited by the Act itself.
Right.
So keeping that in view, I don't see that this is a valid concern which is being expressed, because the law itself, the proposed law itself, make a provision for that.
And there are safeguards.
There are safeguards.
Right. Chakshu Roy, a lot has been spoken about the board as well, even in today's discussion. Role and functions of the board, really.
Fairly widespread, very exhaustive. One of the things that Mr. Malhotra, actually two of the things that Mr. Malhotra referred to, I would like to reiterate. One is the proof of the pudding is in the eating. So, when the law gets implemented, we'll have to see as to is there a gap between the intent and the implementation, and to ensure that there is no gap between how the bill was envisaged and how it gets rolled out. That has to be ensured at the legislative level. Now, the bill has been introduced, it is currently pending in the House. If the bill goes to a parliamentary standing committee, the committee can potentially come out with a report before the beginning of the winter session, and that will serve two purposes. One, experts will be able to come and tender their evidence before the committee. Concerned citizens can also come and appear before the committee. Lawyers like Piyush can also go and testify. It will help strengthen the bill, and it will possibly also help the political parties come on board in the same plane as to the to the language.
And it will be holistic.
And holistic.
Yes,
that's
all
correct.
right. Yatish Rajawat, talking about political parties, certainly this issue has taken a political hue, like you pointed out in your opening remark as well. How do you see it going forward?
So, I mean, Frank, this is a 158-page bill, and data, as you were talking about earlier, has a whole chapter devoted to it. Concerns about privacy has been clearly addressed in it. I have not seen a more exhaustive bill, like 158. You rarely get a bill which is 158 pages, for instance, in the first go. So, the opposition can continue to say that this is, it does not address issues that they would like to be addressed, and they can address those issues in the parliamentary committee that will sit on this bill. But I think, moving on, it's important that a bill that has been in the pipeline for almost, like we've been having these discussions in 2007. And, in 2012, we had a draft bill which was almost ready to go into parliament, and it was again, almost stopped because of opposition to it. So, I mean, in 10 years, we've lost an edge in capturing this space, both from a scientific point of view and from an investigation point of view.
Right. Okay.
So
yes.
many cases
Mr.
would have been
Mr.
solved
Malhotra wants to
better,
come in.
done better,
I've got limited time, so sorry to cut you short, Yatish. Yeah.
Yatish, I think I'll make a small correction here. Bill is in front of me. In fact, it runs into 61 section and has a schedule attached to it, which runs into about not 151, about 30 pages or so. But as you have very rightly said, it is exhaustive. It make a provision with regard to all the concern which have been expressed by various sections of the society. But ultimately what the parliamentary committee decides on it and how the bill goes and how it is implemented will be more important from our point of view.
Quick closing comment from you, Piyush.
Frank, second thing, people are comparing it with the Aadhaar Act and like DNA is going to be collected of all of us, all the Indians. No, it's not like that. So it's a very benevolent piece of legislation, and my prediction is there are going to be more voluntary submission of DNA profiling than the government collecting it.
All right.
There are going to be people submitting their DNA profiling for accessibility to justice rather than government taking it. So that's my prediction for it.
Okay, on that note then, I'll have to call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. That's it on this edition of The Big Picture. See you again next time.